This far, we have focused on civil liability, meaning an accountant would be held liable for damages to a private individual or entity, generally for money, right? Money is what people want in the end. That's what they've lost. Criminal liability is a bit different. Criminal liability arises when an offense is deemed criminal. It's a wrong against society. A person or entity is punished for their actions to hopefully deter them from engaging in similar conduct and to deter others from engaging in that type of conduct. Criminal liability consists of paying a fine or being imprisoned or both, depending on what the offense is. The Department of Justice has the right to prosecute willful violations under either the 1933 or the 1934 Acts. The Internal Revenue Code imposes various criminal penalties on accountants for wrongdoing in the preparation of tax returns, and many states prosecute violations of their own security laws. Many states actually have enacted the Uniform Securities Act, which is patterned after the federal act. New York is not one of them, but it does have a body of law regulating securities in New York State. And that is the task of the Attorney General. If the Attorney General believes that our security laws have been violated, then she is the one tasked with taking on or prosecuting the individual or entity. Before we move in to talk about the Sarbanes-Oxley Act 2002, I just want to say that the portions of the 1933 Securities Act and the 1934 Securities Exchange Act, we're just talking about some liability components. Those bodies of law, as you can imagine, have many, many other laws embedded within it that are irrelevant to this discussion. I was just pointing out the liability components. A new law, the newest law in securities, is the Sarbanes-Oxley Act of 2002, or SOX. You might be familiar with it already. During the late 1990s and into the 2000s, many corporations in the U.S. engaged in fraudulent accounting to report inflated earnings or to hide their losses. Many accounting firms hired to audit these corporations failed to detect any fraud. Enron is the story. Probably the biggest corporation, kind of led the charge on this one. By the early 2000s, the stock market tumbled. Congress stepped in, hopes to restore investor confidence by passing the Sarbanes-Oxley Act of 2002. The goals of the act, or for Congress, that this act would do, to improve financial reporting, eliminate conflicts of interest, and provide government oversight of accounting and auditing services. So let's review the provisions as it relates to the auditors. The Act created the Public Company Accounting Oversight Board, PCAOB. It includes 5 members, all with financial backgrounds, appointed by the Securities Exchange Commission for terms of 5 years. 2 of these individuals must be CPAs and 3 do not have to be CPAs or can't be CPAs. So 2 are CPAs and 2 are not, as then they all have to have some sort of financial backgrounds. The board ensures that the investors receive accurate and complete financial information. So this board has the authority to regulate public accounting firms. They establish everything from audit rules to ethic guidelines. All accounting firms that audit public companies must register with the board, and the board must inspect them regularly. For firms auditing more than 100 companies, they are inspected once a year. For firms auditing less than 100 companies a year, it's every 3 years for their inspection. The board can discipline accountants and firms. They can order sanctions, including suspending or revoking license, as well as assessing any civil monetary sanctions. The board has reported, interesting factoid here, the board has reported that it found flaws in over a third of the audits performed by the Big 4 accounting firms. And sadly, that percentage has increased over time. The Act makes it unlawful for a firm to provide auditing and non-auditing services. If the firm audits, they cannot provide bookkeeping services, human resource services, investment services, legal services, broker services, and anything else the board determines that it can't. However, a certified public accounting firm may provide tax services to audit clients if such tax services are pre-approved by the audit committee of the client. I'm going to get to the audit committee in a minute and that requirement. According to the Act, each audit is assigned an audit partner of the firm to supervise the audit and approve the audit report, and also requires a second partner to review and approve audits prepared by the firm. So there's a lot of checks and balances that the Act has implemented against accounting firms when they're doing auditing. The Act also regulates certain employment arrangements. Think of conflicts of interest, right? An accounting firm cannot audit a company if one of the client's top officers has worked for the accounting firm within the prior year and was involved in the company's audit. On the flip side, nor can any person employed by the public accounting firm that audits the client be employed by the client in a top officer's position for 1 year following the audit, trying to avoid any conflict of interest in that scenario. Our audit committee, I just mentioned the committee a moment ago. Traditionally, auditors reported to the top management of a client. But this poses an obvious conflict of interest since the auditors are reporting to the very person or people who may have been causing any sort of problem. So the Act requires that the company have an audit committee that is composed of independent members of the board of directors. And these have to be outside board members who are not employed by the corporation. And one of those members must be a financial expert. So the company itself that's being audited must have a neutral audit committee in place. There are some other accountant-client relationship issues needing to be discussed. Let's explore those. SEC rules require accountants to maintain independence from the companies they audit. So accountants, quote, must be capable of exercising objective and impartial judgment on all issues. So the rule is an auditor or family member must not maintain financial or business relationships with a client. The SEC prohibits the auditor or family member from owning stock in companies the firm audits. This was a big violation of PricewaterhouseCoopers. Their partners were in violation of this rule, including the partners who were charged at the firm for enforcing it. There were a total of 8,000 violations, and a few years later they were caught violating it again. The SEC had to notify over 50 of the firm's clients that there were concerns about the integrity of the financial statements. Important to note, the Securities Exchange Commission can ban any accountant who engages in unethical or improper professional conduct from auditing any publicly traded company. So, can be banned. Sometimes accountants' clients are sued in court, and the court seeks information about the client from the accountant. The question comes up whether there's a privilege, meaning that the accountant does not have to provide information or testify regarding the client's information or communications. This, you may have heard the attorney-client privilege, the clergy privilege. So there's a spousal privilege that a spouse cannot be required or ordered to testify against another spouse. Certainly an attorney cannot testify regarding their client information or communication. In limited circumstances, doctors don't have to. About 20 states have created such a privilege that provides an accountant cannot be called as a witness against their client. New York is not one of those states. Also, this rule applies only in those 20 state courts where it's enacted, so it does not apply in federal court. And of course, the statutes we just discussed are all federal laws. The Securities Act, the Exchange Act, the Sarbanes-Oxley, the IRS code, these are all federal laws, which end up in federal court, which means there's no privilege. The United States Supreme Court has held that there is no accountant-client privilege, which means at the federal level, an accountant can be called in as a witness in cases involving federal security laws, federal mail or wire fraud, federal racketeering cases, and any other sort of federal cases or federal crimes. One last point, accountants' working papers. Accountants use their clients' information. the client's documents, to prepare working papers like notes or memorandum. They conduct research, they do data collection, they write opinions, they have explanations. These documents, just like the testimony, are not protected, which means we use the term discoverable, which means they can be obtained and brought into court against a client. Federal law allows for an accountant's work to be discovered. A few states do allow for a work product immunity. This, by the way, only exists with attorney clients. There's a work product immunity, meaning that the papers cannot be discovered or brought or used into court, but most states do not provide this protection, even less than the 20 states that allow for the privilege. A couple other points on this working papers idea. Client controls the accountant's working papers, meaning the accountant cannot show the working papers to anybody without the client's permission, or, as I just stated, a court order that says, turn over your paperwork. The client must be allowed at all times to be able to access that paperwork. Clients are in control. Under SOX, accountants for public companies must keep all audit paperwork for at least 7 years. So that's the note on accountants' working papers. And this concludes this whole section on accountant liability.